Okay, we'll get started. Everybody hear me all right? Okay, I'm Jack Pitney. I teach at Claremont McKenna College. Today I want to talk about contemporary political issues and the Constitution. And before I get started, even though I teach college, I do have elementary school children, so I've been most interested in a lot of the material today. More interested than my daughter is. My daughter, who has just started third grade, sat in on one of my classes last year, and I tried to make this really exciting class about Congress with lots of C-SPAN clips and drama, and afterwards I said, "Hannah, do you have any questions?" And she thought for a second, and she said, "Yes. Why do you teach boring stuff?" So that's the way it is sometimes with second graders. My son, who is in sixth grade, lost a race for student council president, but I used that as a teachable moment to tell him a remarkable fact, that in the past 50 years, the winner of every single presidential election had previously lost at least one election. President Reagan, for instance, lost the key 1976 primaries against President Ford. And you go all the way back to LBJ, his first race for the Senate, he lost to Pappy O'Daniel. Of course, he didn't draw quite the kind of elevating lessons one would hope. The main lesson he drew from that is, gotta steal more votes. Which he actually applied in the 1948 election, if you're familiar with Robert Caro's books. But that's not really what I'm focusing on today. I want to focus today on the Constitution. Now, I think everybody should have gotten a handout. And one of the things in the handout, this link to one of my home pages, a whole bunch of resources on the Constitution, the courts, civil liberties, and civil rights. And if you go to this, I know in the previous session there was a lot of discussion about finding reliable information on sites. Well, here you can find primary source materials, Federal Judicial Center, Supreme Court. Does anyone use OYAS? Okay, good, yes. Terrific, because at OYAS, and it is pronounced OYAS, not Oye. Well, you can't pronounce it Oye, but it's Norman French. So they pronounce the Z. You see, you get a little French lesson here too. Oral argument. You don't get video, but you do get the audio of oral argument. You can even get the oral argument, for instance, in Brown versus Board of Education. Fascinating stuff. If you're teaching constitutional issues, one case that I particularly like is Edwards versus Aguillard. Not one of the more famous cases, but it's a 1987 case involving Louisiana law requiring the teaching of creationism. If a school is going to teach evolution, it also had to teach creationism. And went all the way to the Supreme Court, and the court struck it down on a 7-2 vote. Fascinating case because it illustrates the special role of religion in American politics. In a lot of developed countries, this wouldn't be an issue. You wouldn't be talking about teaching creationism. But because the United States is a peculiarly religious country, it is a big issue here. About the role of federalism. In a lot of other countries, educational policy is made at the center. In France, for instance, education in France is determined in Paris, and that's that. In the United States, as we all know, we have 50 different sets of educational policies, 51 if you count DC. Also, the role of interest groups in bringing cases to court. One of the reasons this case got to the Supreme Court was the role of ACLU, who used Don Aguillard to create a test case to challenge the Creationism Act. And also the importance of oral argument itself. because there were some very interesting issues that came up during oral, and Jay Topkis, who was the attorney for ACLU, scored some really, really big points during oral about the wording of the law. Anyway, I just throw that out to you as one example. If you want to pick a Supreme Court case where you can touch a lot of bases all at once, and it's a pretty accessible case. You know, a lot of Supreme Court cases deal with really, really complicated, abstract legal issues. This one, I think, by the time you get into 6th, 7th, 8th grade, it's stuff that it's not hard for kids to understand. The basic legal issues, very transparent. Okay, and if you go to my homepage, I have links to just about every topic in American government that you could imagine. Links in the presidency, Congress. So I throw this out to you. If you find these sources to be useful, great. If not, well, I'll never know. So this is a site that you might want to take a look at. Now today, when Tony asked me about this topic, originally I thought, well, the hot topic could be the Affordable Care Act, and it is still a pretty hot topic, but when it comes to the Constitution and contemporary politics in the past few weeks, something even hotter has gone to the top of the agenda, and that, of course, is the war power. This has been an issue in American politics, since, you know, the Constitutional Convention. This is a golden oldie, and it's a great occasion, a teachable moment, if you will, to talk about enduring issues in American history, enduring issues in the separation of powers, to which there will be no end. I've been teaching about the war power ever since I started teaching the presidency in the 1980s, and when I retire in another 20, 25 years, I have small children, so I'm on the late retirement plan, I will still be teaching about controversies involving the war power, and those controversies will not be resolved. So what are we talking about here? ISIS, ISIL, whichever formulation you prefer. Let's just see a little bit of President Obama's speech the other day.
So tonight, with a new Iraqi government in place and following consultation with allies abroad and Congress at home, I can announce that America will lead a broad coalition to roll back this terrorist threat. Our objective is clear. We will degrade and ultimately destroy ISIL through a comprehensive and sustained counterterrorism strategy. First, we will conduct a systematic campaign of airstrikes against these terrorists. Working with the Iraqi government, we will expand our efforts beyond protecting our own people and humanitarian missions, so that we're hitting ISIL targets as Iraqi forces go on offense. Moreover, I've made it clear that we will hunt down terrorists who threaten our country wherever they are. That means I will not hesitate to take action against ISIL in Syria as well as Iraq. This is a core principle of my presidency. If you threaten America, you will find no safe haven.
Okay, then if you go to the White House website, or many others, you can find the full text and video of the president's speech. So this is going to be a really big deal, at very least for the coming semester, and quite possibly for a long, long time to come. So, even aside from the policy issues, which are extremely difficult and way above my pay grade, I mean, what really should we do against ISIL? I wish I knew. This raises issues about presidential authority, the presidential war power. Does the president have the authority to issue such an order? Does the president have the authority to call in airstrikes? Well, there are different opinions. Now, one thing to keep in mind, and this is a discussion starter for class. The difference between your approval of the individual president, your approval of the policy, and whether you think what the president is doing is constitutional. This is an illustration of the old principle in constitutional arguments in Washington: where you stand depends on where you sit. That you will find when there is a Republican president. Republicans are big on presidential power. We have to support our president. You can always tell in Washington a speaker, you can pretty much guess what party that person belongs to when they start talking about our president. I remember working in Washington in the 1980s, and I was working on Capitol Hill. Our side, the Republicans, referred to President Reagan as our president. Then, when you have a change of administrations, switch. When Bill Clinton was president, Republicans suddenly discovered Article 1 of the Constitution, giving power to Congress. Wait a minute. We have to curb presidential power. We have to establish the appropriate congressional role, as the framers of the Constitution insisted. And of course, Democrats changed positions too. Democrats were all of a sudden, yes, we have to stand behind, you guessed it, our president. So that's something to flag for students, to be aware that sometimes partisanship can color constitutional arguments. And for them to reflect, to ask the question, if you disapprove of what this president is doing, would you approve if a president of your party was doing exactly the same thing? Conversely, if you say, no, we have to limit the president, well, what would you do in the opposite case? Something for them to think about. The two issues in politics are often commingled, but you really ought to be able to separate them. Let me give you an example of the kind of criticism we're hearing now from Republicans. Again, Republicans, 2007, 2008 were big on presidential war power. Constitutional issue, an argument between two lawyers. Megyn Kelly, as you know, is a lawyer. Ted Cruz, former Solicitor General of Texas. Let's see how this conversation goes.
Let me ask you this, because the president did make a reference to Congress today, saying he doesn't need your approval to do this, but we're stronger if he has it. A few years ago, Senator Bob Menendez, a Democrat of New Jersey, tried to push through a bill that would arm the Syrian opposition. Harry Reid did not allow that to come to the floor for a vote. So the question tonight is, will Congress unite behind the new plan, and do you think they need to?
Well, I think the president should come to Congress and ask for authorization. You want a demonstration of presidential hubris, look no further than this speech tonight, where he brazenly declares, I have the authority to wage war regardless of what Congress says. My copy of the Constitution says Congress has the authority to declare war. Now, the president has inherent authority as commander-in-chief to respond to an exigent threat. But President Obama didn't propose any response to an exigent threat. He proposed a multi-year military campaign, and he proposed ignoring Congress other than he would deign to accept congressional approval if Congress gave it. Part of the reason for seeking congressional approval is it forces the president to go in front of Congress and the American people and articulate a clear military objective that furthers U.S. national security interests. The president has failed to do so, and it appears he still doesn't intend to do so.
Senator Ted Cruz, thanks for being here, sir.
Okay, now, if this were a Republican president, do you think this conversation would be unfolding the same way? Probably not. So that's, again, another teachable moment about how partisan positions can influence constitutional argument. But let's go to the primary source document. What exactly does the Constitution say? And in a case like this, what I like to do, and I think it's useful at all levels, read the Constitution. Look at the relevant sections. And by the way, the links here are what I think is a terrific resource on the Constitution is FindLaw. Anybody use FindLaw? Yeah. really good. The annotations are wonderful. You can go as far into the weeds as you want on case law, on interpretations, etc. So a lot more detail off the link. So, what are the powers of Congress? To declare war, to grant letters of marque and reprisal, to make rules concerning captures on land and water. Okay, let's get a conversation going. What does it mean to declare war? Anybody? Not a rhetorical question. Chime in. What does that mean? Yeah.
We're going to war. We have declared war against another party, setting forth a force and enemy, real or perceived.
Okay. What is the difference between declaring war and making war? Are they the same thing? Okay. There's no right or wrong answer, by the way. People have disagreed. And that's a question. Is it valid to make war without a declaration? Well, when was our last declaration of war? Actually, technically 42. The big ones were in 41, but we had a series of we declared war against Romania. So we had the asterisk declarations of war in 1948, but the big ones were, you're right, were in 1941. And I want to come back to that in a few minutes about the consequences of the declaration of war. So that's an issue in itself, declaration of war. To grant letters of marque and reprisal. This, by the way, is a great quiz question. You can really tell the nerds in your class if they know what letters of marque and reprisal are. What are letters of marque and reprisal? Anybody? Yes, letters of marque and reprisal.
Isn't that where the government allows a private individual to wage war?
Yeah. But, you know, it's only a slight distortion to say government puts out contracts. And if you want, I have a link here that goes into some detail. We signed an international treaty in the 19th century, so that's not something we do anymore. But it's kind of fun to know about. To raise and support armies, but no appropriation of money to that use shall be longer for 2 years to provide and maintain a navy. Now, interesting question. The Constitution specifies that the appropriations for the Army shall be no more than 2 years, right? But it doesn't say anything about the Navy. Why did they limit the time, why did they put a time limit on appropriations for the Army but not the Navy?
Sometimes when you send the Navy out with the kind of folks that ship they have then, it'd take 1 or 2 years to get there and back.
You bet. And what else? Why did they put a limit on the Army?
Because they didn't want a standing army hanging.
Yeah. If you read the Federalist Papers, constantly, over and over again, there's the discussion of standing armies. Because they're afraid of a coup. Which, and Madison and Hamilton were very much aware of the history of the world, and that was not an idle threat. And they figure, armies do coups, navies do not do coups. Because if you're just 20 miles inland, the Navy can't do much to you, or at least couldn't do too much to you in the 18th century. So that's yet another teachable moment. The concern of the framers about military power, about having a military coup. And if you really want to get students engaged, anybody ever see 7 Days in May? Oh, wonderful 1964 movie with Burt Lancaster and Kirk Douglas about a military coup in the United States. So if they're starting to nod off, show them some clips from that. It's a terrific movie. Anyway, to make rules for the government and regulation of the land and naval forces. Now, that seems pretty straightforward, but what's a big issue that was fairly recently resolved involving rules for the government and regulation of the naval and land and naval forces? The Congress got involved in, the President got involved in. I'm sorry? Yeah, don't ask, don't tell, and finally that got settled. But that was a big deal. It went before Congress, and why did Congress get involved? Because they make rules for the government of the naval and land forces.
Would this also include the recent long-care issue?
Yes, absolutely. And this is an issue I track, the whole issue of TRICARE, the authority of TRICARE to cover applied behavior. And now we're really getting into the weeds. But that's also an issue that goes before Congress. In fact, when you think about it, one of the major social welfare agencies in the United States is the Department of Defense. They provide all kinds of health services, not only to active duty military, but to military families, and that's a lot of people. And that originates, if a Tea Party person says, where does the Constitution give you the right to do that? It goes, right there. There it is. Okay, so, powers of Congress to declare war, well, that kind of suggests, well, we can't make war without Congress. Well, look at the next one, powers of the President. President shall be Commander-in-Chief of the Army and the Navy of the United States and the militia of the several states when called into the active service. Okay, what's the militia? National Guard, yeah. So, what does it mean to be Commander-in-Chief? What is the scope of the power of the Commander-in-Chief versus the scope of the power of Congress authorizing declarations of war? Sorry?
One can declare and the other can fight.
And the question is, what is a declaration? Can we fight without a declaration? Yeah, we have. And the question is, and I'll show you in a second, we've done it a lot. The question is it legitimate under the Constitution? People have been arguing about this line, again, ever since the founding, and this is never going to be resolved. But it's a great way to get a discussion started. You have one side of the class say, you can't fight without Congress. The other one says the President has extremely broad power. And this debate is going to be top of the news for the next several weeks because of what's going on in the Middle East. Now, declared and undeclared wars. Now, if you're teaching history, how many wars have we had in the United States? Well, we've had a fairly limited number of declared wars. Oh, by the way, was the Civil War a declared war? Did we declare war? No. Yeah, because if we had declared war, that would have been equivalent to recognizing the Confederacy as a separate country, which was the last thing that Lincoln wanted to do. In fact, Lincoln never referred to it as the Confederacy. I always referred to it as a rebellion, or at most you would call it the so-called Confederacy. So the Civil War was not a declared war, but I think most people would say that was a real war, all right. For sure. So here is a list of declarations of war. It's not a very long list. World War I, War with Austria-Hungary. And the last one, declaration of war with Romania. I bet you didn't even know that we declared war on Romania, but there it is, 1942. But that's it, 1942. That was a long time ago. Gee, why haven't we had a declared war since 1942? That's also an interesting question because people, you know, this is a question you might pose. Okay, we're starting military action, right? Why doesn't the president go to Congress and ask for a declaration of war? I'm sorry?
Doesn't have a majority.
Okay, that's number one. Might not be able to get a majority. Number two, yeah,
Probably because we're not going against another nation.
yeah. Can you declare war?
It's kind of great.
Yeah, can you declare war against a non-state actor? Now, in the case of ISIS, it's somewhat ambiguous because in its sphere of influence, it's actually starting to act like a government. In some of the cities, they have police forces, but do we want to recognize that? Yeah.
Does it have anything to do with our acceptance of the UN? Is it because we're part of coalitions?
In 1950, with the Korean War, that was a UN action. Technically, it was a UN police action. If you've seen episodes of MASH, there are episodes of MASH where they say, oh, police action, right? Are we going around arresting people or what? Possibly could be some concern in this case for the UN. Another one that I never thought of myself until I had an old buddy of mine who had worked in the Justice Department talk to my class. And he'd actually looked at these issues from a legal standpoint. And he pointed out something I never knew before, that a declaration of war has profound legal consequences. And I won't go through all of them. We could spend the rest of the afternoon doing nothing but that. Congressional Research Service, by the way, is a terrific resource, about as close to objectivity as you can get. And this goes through all the legal implications of the declaration of war. For example, there are a lot of contracts with clauses involving declarations of war. Insurance policies don't cover activities under a declared war. The president gains all kinds of powers in a declared war that the president ordinarily would not have. For instance, quarantine power, which basically if we have declared war, the president can declare a quarantine unilaterally and say, you're sick, you're quarantined, which is basically a way for the president to imprison anybody he wants. And as we discovered during the Second World War, giving kind of unilateral power of president to separate people is not a good thing. So that is a little noticed, but also extremely important reason why members of Congress, at least the ones who have consulted counsel, are reluctant to go for a declaration of war. It gives a lot of power to the president. Yeah?
Also with the fact that if we declare war, then like all NATO countries within that also follow?
That's entirely possible. Yeah. Because the last declaration of war was 1942 and NATO did not exist. Now again, you have to look at the fine print of the NATO treaty to see, well, does that mean that if we're in a declared war and the enemy attacks us, does that constitute an attack under the NATO treaty, which is why international lawyers make lots of money. In fact, a lot of times in class, students will ask difficult legal questions just like that. My sage answer is, that's why you go to law school. So if you're interested, again, the link is here. All kinds of legal implications of a declaration of war. Okay, use of military force abroad. So for history, you can quiz your students, name all the wars. Very few people can. There are just that many. They probably remember the semi-big ones like the War of 1812. They may have heard of it because of the year. They can make a pretty good guess when it happened. A little hazy about who fought whom for what reason. In fact, people at the time were a little hazy about why we were fighting the War of 1812. But there were lots of other wars. One war they ought to know about, the Tripolitan War, sometimes referred to as the war against the Barbary Pirates. Why is that significant? Why is that something we ought to know about in 21st century America, even though it happened under Jefferson? The Tripolitan War. Yeah. Well, it was a slightly, the same continent, a little farther away.
Modern pirates that we get off.
Yeah, piracy. Yeah, this was, again, under Thomas Jefferson, we had a conflict with the Islamic world. This is not new. We had a conflict with the Islamic world under Thomas Jefferson. And Thomas Jefferson, of course, being intellectually curious, wanted to know about the other side. That's why he had a Quran. And when the first Muslim member of the House of Representatives took the oath of office, he took it on Thomas Jefferson's Quran. Yeah. Keith Ellison. Keith Ellison is a very smart guy because when he was about to be sworn in, he said he would take the oath on the Quran, and people were saying, well, how can you do that? The answer is, of course, you can. But he took it on Jefferson's Quran, which was a very, very politically savvy thing to do. So historically, you've got the Tripolitan War. How about the Philippine insurrection? What was here in California, we have a lot of Filipino Americans. Other Americans don't know about the Philippine insurrection. Filipino Americans know about the Philippine insurrection. This was a guerrilla war. And in fact, a lot of the U.S. military's doctrine on fighting guerrilla wars was a direct outcome of the Philippine insurrection. It was kind of like Spanish-American War Part 2. Of course, it was the part of the war that didn't get a lot of attention even at the time and tends to be overlooked in history books. So we've had many, many, many military conflicts. We were talking over lunch about Grenada. That was a short one, but it's something that students ought to know about. So we've had many, many, many military conflicts over the years, very small number of declared wars. So this is important not only for understanding the Constitution, but also just for understanding the specific discrete episodes of American history. The War Powers Resolution. This provides statutory authority for waging war in the absence of a declaration of war. Passed in 1973 over President Nixon's veto, was a direct result of the Vietnam War. The idea was to curb presidential war-making authority. Has it been a ringing success? Okay, I see some skepticism in your faces, yeah. Even the people who drafted the War Powers Resolution said, didn't really curb presidents the way we kind of hoped it would. Which raises another set of questions. Why not? Why didn't the War Powers Resolution curb presidential war-making authority? Well, one reason, no president has ever explicitly said the War Powers Resolution is constitutional. Even Obama, even President Obama, if you read carefully letters he sent to Congress about military action, he's always careful to say consistent with the War Powers Resolution, not in pursuance or in conformity with the War Powers Resolution, an important legal distinction. So even our less militaristic presidents have not acknowledged the constitutionality of the War Powers Resolution. Why not? Why do you think? If you're president, why don't you acknowledge the constitutionality of War Powers Resolution? Yeah, you want to keep options on the table. You don't want to limit yourself. And sometimes presidents come in thinking, okay, I'm going to be different, and then they start getting briefings from the Pentagon and the CIA, and they start thinking, maybe I want to keep my options open. People have different points of view when they become president. And a good example is President Obama. Now again, I don't mean to single him out. You can do this for every single president. He's just the one that's there right now. So I don't think I'm knocking Obama in particular. That you can find similar reversals to any president you like or don't like. This was an interview with the Boston Globe in 2007. So, does the president have inherent powers under the Constitution? Key phrase, the president does not have power under the Constitution to unilaterally authorize military attack in a situation that does not involve stopping an actual or imminent threat to the nation. That's what he said. Somewhat different point of view today. Why do you think, and again, regardless of whether you approve or disapprove President Obama, what would be a logical explanation for why he took this position in 2007 and took a very different position this past week? Yeah, bingo. Yeah, different job. When you're a candidate, when you're a senator, you're naturally going to sympathize with the legislative branch. Where you stand depends on where you sit. And again, you can find this with any president of any party. One example I like to give to my class, in a debate with Al Gore in 2000, George W. Bush, then governor of Texas, said he would have a, quote, humble foreign policy. Now, whether or not you approve of President Bush's foreign policy, one adjective one would not apply to his foreign policy is humble. But again, he was looking at the world as it looked like in 2000 as a presidential candidate talking to an electorate that was focused primarily on domestic issues. He can sort of understand where he was coming from. Very different world opened on 9/11/2001. So let's talk more broadly about constitutional issues and the power of the president. The executive power shall be vested in a president of the United States of America. Now, one thing I like to do is compare that with the beginning of Article 1. All legislative powers herein granted. Subtle difference. The executive power seems to be indefinite. All legislative powers herein granted seems to circumscribe legislative power. And that was intentional on the part of the framers. In Federalist 51, Madison wrote, in Republican government, the legislative authority necessarily predominates. The legislative authority. So the framers were particularly interested in curbing legislative authority. He shall receive ambassadors and other public ministers. Now that may sound like a mere technicality, but courts have routinely read that as giving the president wide power over foreign policy. To receive public ambassadors and ministers implies the power of recognition. And diplomatic recognition, of course, is a cornerstone of any foreign policy. He shall take care that the laws be faithfully executed. Now, what does that mean? Okay, from the point of view of Congress. Now, if you're the president, be faithful. Faithful to what? Faithful to whom? Faithful to what Congress wants, or faithful to the Constitution? Faithful to the higher law? Faithful? It's one of these words that presidents look at and say, you know, that means whatever I want it to mean. Okay, let's look at a couple of uses. What are signing statements? Now, that's an executive agreement. That's another instance of presidential authority, and President Obama is talking about an executive agreement on climate change. So that's another way in which President exercises authority. Yeah. Yeah, that's right. The signing statement says, okay, I'm signing this bill, and by the way, bureaucracy, I regard sections 6, 9, and 11 as unconstitutional, and I'm not going to carry them out. Presidents have been issuing signing statements since Andrew Jackson. And members of Congress are routinely resistant. President Obama has frequently used signing statements. And you can get a whole list of them right there. However, Senator Obama, however, had a different point of view.
When Congress offers you a bill, do you promise not to use presidential signage to get your way?
Let me just explain for those who are unfamiliar with this issue. We've got a government designed by the founders so that there be checks and balances. You don't want a president who's too powerful, or a Congress who's too powerful, or a person who's too powerful. Everybody's got their own role. Congress's job is to pass legislation. The president can veto it, or he can sign it. But what George Bush has been trying to do as part of his effort to accumulate more power in the presidency is he's been saying, well, I can basically change what Congress passed by attaching a letter saying, I don't agree with this part, or I don't agree with that part. I'm going to choose to interpret it this way or that way. That's not part of his power. But this is part of the whole theory of George Bush, that he can make laws as he's going along. I disagree with that. I taught the Constitution for 10 years. I believe in the Constitution, and I will obey the Constitution of the United States. We're not going to use signing statements as a way of doing an end run around Congress. All right.
Well, he has used signing statements. But again, I'm not picking specifically on Barack Obama. You see this time and again with presidents of both parties. Because once you get in the office, you're not a senator anymore. You're not looking at it from Capitol Hill. You're looking at it from the other end of Pennsylvania Avenue. And you may sincerely believe that certain sections of a bill are unconstitutional. And if you are going to faithfully execute, and if you think faithfully means faithful to the Constitution, well, that's a different point of view. I skipped over executive orders. We'll leave a few minutes if you want to talk about executive orders. We can do that too. There's a lot of talk about impeachment. Okay, I'm going to make a bold prediction. President Obama is not going to be impeached. Mainly because you still have some Republicans in Congress who remember what happened the last time they impeached a president. That didn't work out too well for him. 1998 midterm, usually the party out of power gained seats. The Reaps lost seats in 1998, and some of the folks who opposed who supported impeachment were no longer members of Congress after the 98 election. So that didn't work out too well. Important thing for students to know, there's a difference between impeachment and conviction. Impeachment is roughly equivalent to an indictment. Bill Clinton was in fact impeached. But what happened? Is there? Not convicted in the Senate. It takes 2/3 vote to convict in the Senate, and didn't come anywhere close. Curiously, you even had some Republican senators who voted against conviction. Fred Dalton Thompson, who's a lawyer, not only played one on TV, actually was one in real life. He didn't think, at least on one or two of the counts, they didn't have the goods on him. So he voted to acquit. And the question, one interesting question is grounds for impeachment. which you can find there, which, if you look at the link, high crimes, treason, bribery, other high crimes and misdemeanors. What's a high crime or misdemeanor? What's a high misdemeanor? Is there such a thing as a high misdemeanor? Almost, the best answer to that ever given was by Gerald Ford, who at the time was minority leader of the House of Representatives. He started a movement to impeach Supreme Court Justice William O. Douglas. And his answer to the question is, an impeachable offense is whatever the House of Representatives at any given moment says is an impeachable offense. And the answer is, the reason that's kind of final is impeachments are not reviewable by the courts. You cannot appeal an impeachment under the Constitution. If the House impeaches somebody and the Senate convicts, that's it. End of story. There have been impeachments in the 20th century. We've had impeachments, several impeachments of federal judges. One curious case about impeachment of a federal judge involves a fellow named Alcee Hastings. He was a federal judge. He had some questionable dealings, shall we say. He was impeached and removed from office. And then to get back at the Congress that impeached him, he ran for the House of Representatives and has been there ever since. He is still, to this day, a member of the House of Representatives. Every day looking at the people who impeached him. Because that particular article of impeachment did not specify that he would be banned from office in the future. So impeachment, roughly equivalent to indictment. Conviction is actual removal from office. Again, politically, not likely to happen to President Obama. Also, let me throw a question out to you. Sometimes this may come up in your classrooms. I have trouble dealing with this delicate issue. Suppose people ask, why was Bill Clinton impeached? Yeah, but then they start asking, what did he lie about? And then the conversation starts getting awkward. Yeah, back in the 90s, I could sort of assume that students kind of knew what happened in the Oval Office, but explaining that, and I imagine that's somewhat delicate in grade school too. So just beware, if the discussion gets out of impeachment, the Clinton case is, shall we say, delicate. Then I'll, just a couple of items on the Affordable Care Act, and then we'll talk about anything you want to talk about. The Affordable Care Act, several constitutional issues there. Case in which it was largely upheld involved the interpretation of Congress's power. The opponents of the Affordable Care Act said, look, this section of the Constitution gives Congress the power to regulate commerce. It does not give Congress the power to create commerce. That is, to require somebody to buy a product. And a number of lower courts said, yeah, you got a point there. Went to the Supreme Court, and Justice Roberts did something unexpected. What did he do? Yeah, Justice Roberts confounded everybody who thought he was an absolute certain vote to strike down the Affordable Care Act. He upheld it. How did he uphold it? Yeah, he said, well, notwithstanding that the supporters of this said it wasn't a tax. They swore up and down, not a tax, not a tax. He said, yeah, it's a tax. And whether you say it or not, it's a tax, and Congress has power under Article 1 of the Constitution to lay and collect taxes. And this reaches to the political role of the Supreme Court. Now, I'm sure John Roberts, in his heart of hearts, is not a super fan of the Affordable Care Act. So a question to pose is this: why did he do it? What do you think? What are some possibilities? Why did, yeah. Okay, he was leery about overturning a law. What else?
Because he swore to uphold the Constitution and not to party belief.
Well, the lower courts found that the Affordable Care Act violated the Constitution. That Article 1, you can make an argument that it does not empower Congress to create commerce where none exists. What else? Okay, what else? Sorry, can you speak up a little? Okay, arguably it would create some political problems for the administration. Also, preserving the political standing of the court, because what you will find historically, at times the court has pulled back from controversies that would draw it deeper and deeper into partisan politics. What would have happened if the Supreme Court had struck down the Affordable Care Act? How would that have played in the 2012 campaign? Do you think the court would have been target number one? Could you imagine the attack ads? Hi, I'm going to die next week, thanks to John Roberts. I mean, the attack ads write themselves. And John Roberts is no fool. He knows that. And time again in history, a wonderful book here by Walter Murphy, The Elements of Judicial Strategy. It's an older book, and it talks about some older cases. But same basic idea. So he was preserving the political viability of the court. You have the Hobby Lobby case on the coverage of contraceptives. That gets into issues of the First Amendment and religion. And the case bubbling up through the court right now is that when Congress wrote the Affordable Care Act, it talked about subsidies for policies written on state exchanges, but they failed to specify that the subsidies would apply to subsidies for policies purchased on federal exchange. And given that so many people receiving aid are on federal exchanges, if the court accepts that interpretation, that could seriously damage the Affordable Care Act. So that's a case to watch in the future. Probably getting a little too detailed, more detailed than a lot of students would be interested in, but let's see what they are interested in. We have some time for questions and comments. If you want to raise it from the floor or go to the microphone, either way. Yes, sir. No. If you look at the list of declared wars, there were none. But that's, actually the Indian Wars are a great example of wars without a formal declaration of war. And also, if you look in the Constitution, there are specific references to relations with the Indian nations, treating Indian nations as if they were separate and distinct. This is a fascinating topic, particularly those of you, do any of you have students who live on reservations or Native Americans? Fascinating topic, the legal status of the Indian nations. Extremely complicated under the law. In fact, it was only with the Indian Citizenship Act of 1924 that the federal government expressly recognized that Native Americans are citizens. 1924. Which is weird, since they were here first. Go figure. What else? Come on, this is the Constitution. War, health, life, death, big stuff. What else?
The debate they had last debate, and the thing that happened in the Senate this week, they were talking about free speech rights because it came campaign finance.
Oh, yeah.
And then the Republicans, from what I read, called the issue, and so they had to debate it. They had to spend time. It's more of an election issue.
Yeah.
I don't think most of the United States knows how an amendment can be changed, and everybody panics, and they don't even stop.
Yeah, again, what does it take, let me throw the question out, what does it take to ratify an amendment to the U.S. Constitution? It's not easy, but what vote does it take? Yeah, 2/3 of both chambers of Congress and 3/4 of the states. That is a very high threshold. Now, in this case, this was a proposed constitutional amendment to overturn Citizens United. Again, very interesting teaching case. What do you do when you disagree with a Supreme Court decision? Well, there are various avenues available to you, one of which is constitutional amendment. And a number of constitutional amendments have been a direct result of Supreme Court decisions, including the 26th Amendment granting 18-year-olds the right to vote, because Congress passed a statute giving 18-year-olds the right to vote, and the Supreme Court said, no, you don't have the right to declare the voting age in state elections. You can declare the voting age in federal elections, which meant that if Congress hadn't changed anything, you would have had one voting age for state elections and one voting age for federal elections, which would have made elections even more of a mess than they are today. So, yeah. In the context of voting rights?
No, due process clause of the 14th Amendment. Didn't add, the 5th Amendment was due process federally. In the 14th Amendment, applied due process to states.
Well, in this case, the Supreme Court said that was not, that did not require a voting age of 18, because due process generally refers to legal and civil actions, not necessarily qualifications for voting, although there are those who would have a different point of view. But in this particular case, the Supreme Court drew that distinction, and hence we have the 26th Amendment and the voting age of 18 uniformly across the United States. So this is also a fascinating case about the reach of the First Amendment. The opponents of this said, yeah, it looks nice to try to go after the Koch brothers, but this is a brand new amendment to the Constitution, and it wouldn't be too much of a stretch to see how it could be applied by a hostile administration against, say, the NAACP. So that's a fascinating civil liberties debate going on there. What else?
I can think of something upcoming.
Yeah. I'm sorry?
Internet neutrality.
Okay.
That I ask you to go ahead and therefore, internet access to fight horrible rain for many people. Therefore, they have to sign in.
Possibly. We'll see what comes out of Congress. Right now, that's mainly operating at the legislative level and is a full employment act for lobbyists. If you want to go into a lobbying business and you know something about net neutrality, man, you are set for a long time. And eventually, whatever Congress passes is going to go before the courts, and the lawyers who specialize in this, they're going to make out like bandits too. There is scarcely a political question in the United States, wrote Alexis de Tocqueville, that sooner or later does not turn into a judicial one. And that would be an example. Yes, sir.
About 30 years ago, the Supreme Court said that a legislative veto of executive action is unconstitutional. Does that in effect negate the War Powers Act?
Well, the reason is a legislative veto is for those of you unfamiliar, a legislative veto that either chamber of Congress can overcome a regulation or executive decision. And again, in some cases, legislative vetoes were at the committee level, not just the single chamber. In the case of the War Powers Resolution, arguably, this was an exercise of Congress's power, Congress's war power under Article 1 of the Constitution, so it's a different kind of argument. However, Supreme Court hasn't litigated it. Supreme Court hates to litigate war powers issues. They just avoid it. They say it's a political question. And no doubt there will be some challenges to whatever the president does in the months ahead, and there's little doubt also that the courts will try their damnedest not to rule on it, because they just don't want to get into that. Is the War Powers Act even constitutional? Well, we don't have a definitive decision from the Supreme Court because they don't want to rule on it. What else? Anything else? Okay, well, thank you very much. And if you want to follow up on anything, again, I have links to everything in the handout. If you didn't get the handout, let me know. I'll get it to you.